Okay, we have an update to where Shaq's company was suing Shaq's own son about trademark registration of his name. If you didn't see that original story 2 years ago, I reposted it on my page. And if you don't already follow me, I'm attorney LBJ. I'm an intellectual property lawyer. I help small businesses register their trademarks and copyrights and help them understand brand protection through hot topics like this one. So it appears that the parties came to some type of resolution. Although Shaq was co-owner of ABG, a company that owned many of Shaq's trademarks, the company ABG tried to prevent Shaqir O'Neal, Shaq's son, from registering a trademark for his name. When Shaqir applied for the original trademark, he was a minor, and so he had to get consent from a parent. So Shaquille O'Neal, co-owner of the company, had actually agreed to the trademark registration. Well, 2 years later, there has been some change. The original trademark registration that was in dispute, it has since been abandoned. An abandoned trademark registration or application basically means that the person who was applying, they just gave up. But since then, additional new registrations for Shaqir O'Neal have been filed for the same goods and services as the original trademark registration. We can presume that the parties came to some type of agreement because if you're disputing one trademark for a reason and someone goes to apply simply for the exact same trademark a little while later, you're still going to oppose it. And in the new trademark applications that are also now pending, Shaq signed a consent for the minor to use his name as a trademark. When you register a trademark using someone's name, your own or someone else's, you have to submit a notarized document approving and swearing that you have the rights to use that name. And if you are a minor under the age of 18, then an adult has to give permission. Your guardian, your legal guardian, must give permission to use the name Shaqir O'Neal on your behalf. And we can see that here. A quick internet search did not show any new news in this matter, so that must mean that the parties just very quietly handled this issue on their own. Maybe some type of agreement was written where they limited the use or made it clear how they can internally use it. Or maybe Shaq bust up in the room and said, "How dare somebody in legal sue my son and prevent him from registering his own name?" Either way, they are setting Shaqir up to be able to use his trademark and probably are also trying to prevent other people from trademarking that name or anything close to it. This trademark is filed as a 1B application. That means they're not using it yet, but they do intend to use it. If you haven't already, follow me. Think about all the things you just learned. You can get a trademark in your own name, but if you are a minor, you must get an adult to approve. Trademark disputes can be solved privately and quietly. If you put in a trademark registration and it doesn't go through the first time, you can file again. And you learned about a 1B intent to use application. That means that you're not using it right now, but you intend to use that trademark in the future. Now share this good information with a small business owner who you know probably needs to go ahead and get that trademark started.